Is that better?
Yes.
Sorry. In any event, we have had 4 in Dallas, 1 in El Paso, 1 in Corpus Christi. And we have gone all over essentially all over the country, major cities, having these lunches where we invite the judges and recently discharged jurors, and we talk about how can the procedure be improved. The idea for the Civil Jury Project was to create an academic center, and we are the only one in the country, that asks the question, why are jury trials disappearing in civil cases? Indeed, you will see in a minute, all trials in civil cases are disappearing. And disappearing meaning they're just shrinking. They're not going to become extinct, but it'll be like the California condor. Still in existence, but rarely seen. So, the trends are undeniable. The second question we ask is, do we care? And the answer to that question is, of course we care. The right to trial by jury is the only right that gets mentioned 5 times in our founding documents, in the Declaration of Independence, in the Constitution itself, and in 3 of the Bill of Rights. There's not a courthouse in the country, a courtroom in the country that doesn't have a jury box in it. It's part of the DNA of our justice system in this country. Our founding fathers were under no illusions that jury trials would cost more, last longer, be more susceptible to flamboyant advocacy, less predictable than other types of dispute resolution. And yet they insisted that that was the only means that the average citizen could be protected against a tyrant who appointed judges and told the judges, do what I want. They had to pass a loyalty test to get the king to appoint them, and then the king told them who to convict, who to deprive of property and freedom. And the founding fathers thought that it requires a jury to be a check on that kind of corrupt judicial power. Clearly, we are at a dangerous point in time in this nation, with judges being criticized for their decisions, with the executive branch criticizing, the American Bar Association voted, every legal organization in the country in the last 2 weeks has come out and defended judges and jurors from being criticized for what they did. Essentially tweeted about and criticized in social media for what they do. And so it's an important time to hold on to this right, to try to restore it, make it vibrant again. And that's why we are doing this. The statistics, which I've brought a few to show you. If you can look at this chart here, this shows the average number of civil and bench trials for authorized federal judgeship in the last 57 years. Goes back 57 years, and you see the number of jury trials for authorized federal judge has dropped from 10 to under 2, the red line, and the bench trials have even dropped more. That was something I never knew when I began the project, because frankly, and it's a very good argument that jury trials are not declining because they are more expensive or longer or less certain than bench trials. Because bench trials are declining more. They are declining because either disputes are not being resolved or they're being taken entirely out of the public dispute resolution system. And we know that arbitration, of course, does that. It had the effect of doing it. The Western District of Texas, the average judge here, federal judge, 1.6 for authorized judgeship, and under 1 civil trial per judge. we're kind of slightly below the U.S. average here in the Western District. But you have to ask yourself, and Eastern District of Texas, same kind of numbers, although a little more. 20th in the country. The Northern District of Texas, the same kind of figures. They rank 43rd. The Southern District is pretty busy compared to others, but still nothing to write home about. You can say, well, the number, you should look at the absolute number, and that's probably right because it may vary with filings. But look at the percentage of some determinations. Of all the cases filed in 62, 5.5% of all cases filed were disposed of by jury trials, and today it's well under 1%. It's well under 0.5%. The situation in, and this shows the Western District, the same kind of pattern. If you look at the state courts in Texas, state civil case, same basic pattern, a downward trending line. So what have we done at the Civil Jury Project at NYU? We have a website that has, so this lunch, by the way, is being videotaped, all 37 of the prior lunches. The videos are posted on our website. Researchers can go and look at what other jurors are saying around the country in different parts of the country. We have, one of the things we realized earlier, that we need to get the judges engaged. If we're going to say that the law, if our profession is going to save jury trials in this country, it's got to begin with the judges. Because they have got to want to try cases. They have got to make the trial of cases quicker and cheaper and create the impression, at least create the impression for the public, that the result is going to be sound, just as sound as it would be if a judge or arbitrators tried the dispute. So there's a website. We have 365 judicial advisors. We have 75 academics around the country that have done studies, and we have about 40 jury consultant advisors that also work on various projects. Yes. We have another website called We the People, We the Jury, which we encourage jurors to go to by asking the judges to give them a card when they are discharged. We will give the judges those cards. We simply said, if you want to talk about your experience, you want to write about it, go to this website. It sends them there. And if they have received a jury summons, there's a portal at the left over there. You click on that. Someone says, jurors, just like the ones that are on the panel here today, we have clips, video testimony, short clips, less than a minute or two each clip, where they say, don't delay your subpoena, you're about to have the most exciting experience of your lifetime. Because what we discovered is that people are surfing the web, trying to figure out how to get out of jury duty. And when they get on this website, that's what they're looking for. And so, receive a summons, we hope they go there, and we hope we can persuade them by the various testimonials we've got from around the country. Currently serving on a jury, if they go there, they say you shouldn't be here, the judge told you not to be here. Finish your service and come back. And if it's served on jury duty before, we ask them to complete questionnaires. The questionnaires are pretty comprehensive, and we have had hundreds and hundreds of jurors complete those questionnaires and return the results to us. But this is for jurors. This is the card that we ask the judge to give them, make your voice heard, and it just says, there's the website, go there and express your concerns. We have a presence on social media, hashtag Jury Matters, and there's a lot of discussion about juries going on. So one of the things we did when we got going was to put together what we thought would be a comprehensive list. Each of you has this list of the reasons why jury trials are disappearing or vanishing. And the ones on the left are the ones that are difficult to change. The rules get in the way, statutes get in the way, decisions by the United States Supreme Court or other highest courts of states get in the way. And there's not much we can do about the reasons on the left. Arbitration, for example, the fact that forced mediation. But on the right, the reasons for the decline are things we can do something about. And I'd like to look at this list. You have our address on those sheets. If there's something that we've left off or something that you don't think is right or should be changed, please send us an email, because if we don't identify the reasons, we can't do anything about it. And the thing we are here on really is on the right, the reasons for the decline of easy things. What we're really looking at here is the repeat litigants' perception that juries are deprived of the decisional tools available to judges and arbitrators. And by that we mean all of the things that I'm going to show you a very brief video now that this video was made in 1998 by the International Association.
Thank you for coming. Now, I realize that you were summoned to this class without signing up for it. And you haven't even been told what this class is about. Nevertheless, let me tell you what the rules and procedures are. This course could take a few days or a few weeks. I'm not sure. This course could be taught by 10 or 20 teachers, and it will involve a subject you know nothing about. In fact, if you knew something about the subject to be taught, you couldn't take the class. Each teacher will give you relevant information about the subject, information you'll need for the final exam. However, I will not tell you what is important and what isn't. Not only must you determine what is consequential or not, you must also figure out which teachers have told you the truth. Remind yourself of what you've heard or what you thought was important. Also, you may not ask your teachers any questions, no matter how confusing the lectures are. Nor are you allowed to talk to your fellow students about anything the teachers have said, even though this is normally how you go through a college course, or life for that matter. And while it might be helpful to have a notebook for notes, course materials, or an idea of what the final exam might be about, it ain't gonna happen. However, we will let you look at some of the materials while one of the teachers is lecturing on another important aspect of the course. Now, I won't be telling you what is important in this course, or what the rules are for the final exam, until all the teachers have given their lectures. When I do explain the final exam, I'll spend only 15 or 20 minutes on it, and I will probably use unfamiliar or technical terms that I will not explain. The final will involve only 1 or 2 questions, and you will have 1 sheet of paper to write the answer on. You can then discuss the course with each other, but bear in mind, you will all have to agree on the same answer to receive credit for the course. You will also be locked in this room until you reach agreement. Oh, and one more thing. Depending on your answer, someone you don't even know will either win or lose. Any questions? Good. Let's begin. This will be a rewarding experience for all of us.
So, this is pretty funny, but it would be funnier if it weren't truthful in a lot of courtrooms in the country. Where jurors suffer from lack the tools that judges have or that arbitrators have to resolve a dispute. Why people might wisely choose. I'm sorry. Why people might wisely choose to have their disputes arbitrated or decided by a bench trial. So, what we can focus on are the kind of innovations that deal with these problems, and we have been focusing on them. And the innovations we are going to be talking about today, just to cut through some stuff, every one of them can be adopted by a federal judge without agreement of the parties and with no change in the rule of the law in a civil case. The only one that can't be adopted by a state court judge without the agreement of the parties and without any change in the rules is the prohibition of jurors discussing the evidence before final deliberation. That was probably not permissible in state court unless we changed the rules or unless the lawyers agree, which good lawyers ought to agree to that change. Because of all the things you will hear and we've heard going around the country, that's one that the jurors really like. We now will talk about our panel discussion and talk about some of these things and a couple of things from the audience because I'll forget it once we do the panel discussion. You will get a survey from us by email. We have your email address this afternoon asking you about what we can do to improve these lunches, whether you're interested in doing another one here, what frequency should we do it, and seeking any volunteer to be on the organizing committee next time. We are the catalyst. We began it in San Antonio. It's up to this audience, if you so elect, to continue this as an annual or semi-annual tradition. And the second thing is judges who I'm about to introduce and here, please let us know if you are willing to become one of our judicial advisors, which only means we have your email, which I probably have anyway now. Because that's the only way we can communicate with you by email. If we don't have email, I can kind of guess what the email addresses are. It's as long as I get one. But then, anyway, we don't bother you. We will send you for every month for the last 3 years, we publish a newsletter. You came today, you'll get on our mailing list. And we'd love to get the judges on our mailing list too. And we have a very special program that we have now had over 250 state and federal judges. We bring them to NYU, New York City, for a full-day workshop. We pay the law school pays all of their expenses. And it's a workshop on how to try a jury case. And they get together with judges from all over the country. So we put federal judges on one day and state judges a different day. And it's amazing to me, as I've gone around the country and talked to them, hundreds of judges, how unfortunately judges don't often know what the judge in the next courtroom is doing, what they are doing innovatively. You rarely see a judge sit in another judge's courtroom to watch how that judge is trying a case. Yet we as lawyers, that's how we learn to be trial lawyers. We watch older lawyers, senior lawyers, experienced lawyers try cases. And so now it's important because if we don't have judges who know how to try cases, who want to try cases, then there's nothing we can do. The trials will disappear because we will lose. You can be a trial lawyer without ever having to go to trial, or a litigator without ever having to go to trial. And then judges say, we've heard this complaint, I'd love to try more cases, but the lawyers don't want to do it anymore. So that would be horrible if we were in that situation in this country. In any event, We would like to invite the judges to those programs in New York, and our judges who are with us today are, and I will introduce them if you will stand up briefly, Judge Rosie Alvarado, State Court. Judge Mary Lou Alvarez. Justice Tricia Alvarez. Judge Peter Sakai, who Judge Diaz. Judge Angelica Jimenez. Judge Royce Lambert, who's here. Jason Pulliam, one of our new federal Judge Rodriguez, I know he's in the back there. And so, have I missed any of the judges? Would the jurors now whose names are up here please come forward and we begin our panel discussion. Thank you for coming. And what we know about these jurors, Miss Newland, she was in a case that was tried 3 years ago. 3 years ago this month, March of 17. So and normally when we get jurors who their service is so old, they don't have good memories about what that life is like, except the parking was horrible. The cookies were worse, the air conditioning didn't work, the chairs were uncomfortable, and things like that, okay? And that's not particularly helpful to us to get that kind of feedback. But it turns out that you are a lawyer.
Yes.
So her memory, hopefully, is going to be really, very good about this. And she was also the foreperson, one of the foreperson. In a case of the jury, what kind of case was
It was
that?
a custody modification, child custody modification.
Okay, good. Miss Ferradino, you were in a case that was in May of last year.
Yes.
And your case lasted for 3 days, and you deliberated for 4 hours.
Yes.
What kind of case was that?
It was a hit and run.
State court?
Yes.
You were in state court. We have Mr. Rolando Pena.
Yes,
And he was in a case just recently tried,
that's correct.
in January. A 5-day trial with the deliberations that lasted an hour and a half.
That's correct.
We have Mr. Gilbert Pena. His case was also in January, 8 days of trial and 2 days of deliberation.
About 2.5 days.
And all of you were in different cases, but all state court civil cases. Perfect. So let's begin with you're getting a jury subpoena. Did any of y'all go figure any of you trying to get out of it? Were all of you trying to get out of it? The lawyer was not. I know. I know you were not trying to get out because
You're right.
it's a lawyer's dream come true
Yeah.
to be subpoenaed for jury duty and to be able to serve. I've never done it. I would love to do it. I give my right arm to do it. But so I know you weren't. But how about the other three? What was your reaction?
So when I got mine, I'm horrible at opening mail. So apparently I got it in December. I didn't see it till 3 days before like 3 days before I was supposed to be there. I was really sick when I saw it, and so I was kind of shocked when I received it. So I had just gotten back from Los Angeles. I was out of town for work, and so I told my husband, I was like, I have jury duty. It was sitting in our mail for like maybe a month. I I go, I haven't opened it up or anything. I was going through the mail. I was literally gonna shred everything. So something told me to go through the mail. I was just gonna shred the whole. I had probably a pile about 2 or 3 inches thick of just mail. I was gonna shred everything, but something told me to go through it. Luckily, I did because I was probably gonna shred my jury summons.
All right, Ms. Ferradino, how about you?
I had just gotten laid off, so I was excited to have something to do.
All right, and Mr. Rowland.
No, that was, I was kind of, I welcomed it. I saw it as an opportunity to get a few days or 1 day off of work. Quite honestly, I've been working straight for like 3 weeks, a month, and I was like, finally I get a day off, you know, and didn't know it's going to turn into more than that. But it did seem like I think I received all kinds of advice on how to get out of it. I don't think I got any advice from any of my friends on how to get picked. And I think this was probably my 3rd or 4th time serving, so I kind of knew what to expect.
So you wanted to do it again?
I really didn't mind doing it again, honestly. It was, it's our civic duty when I was.
Okay. Now you're all in state court. And the first thing you do is you go to the courtroom and you go through this process, jury selection, voir dire, where the lawyers get to ask questions. Mr. Rolando, what do you think about that experience?
It was handled well. I was I was early in the group, 5, 4, 3, somewhere in there. So just from past experience, I knew, all right, I know how this is going to work out. But what I didn't really, I think it was still kind of flu season, quite honestly. And I'm not a germaphobe by any means, but I didn't really like having to pass a microphone across to the rest of the panel, just from a sheer fact of, there's some people coughing in the room, and you just like, oh, here we go, So that part of it really kind of, I don't know, I can't say it disturbed me, but it definitely caught my attention. I'm like, gosh, just trying to hold it carefully, but I think that could be probably improved a little bit. The selection process went very smooth. There were good questions. The judge really really moved it along quite efficiently. She kind of asked some questions prior to kind of get some of the stuff out of the way, and then again, it went very smooth.
All right, so I want to ask you about a comment you gave us on we give you a one-page questionnaire.
You read this?
Yes, and your comment was understated, to say the least, probably. I wasn't a big fan of waiting in the hall numerous times throughout the day and having to keep our voices down. So when you say waiting in the hall after the trial began?
No, throughout the trial, and I understand the reasons for, hey, can you all leave the courtroom for a little bit and go back in and out. And I understand the reasoning behind that. But when you get into the 3rd day, or even maybe the 2nd day, you kind of, as a group, you kind of want your own space, as a group, because you start making friends with some of the other folks, and yes, the conversations can get a little jovial and loud, the bailiff was outstanding. And he would come out and kindly say, hey, can you keep it down? And we'd be like, oh, sorry. But if we had like a little space to, maybe the deliberation room or something where we could just kind of go in and relax a little bit and have a little bit more comfortable chairs to relax. Because, and at the same time, we kind of, I hate being long-winded, but we have, everybody's got your professional life and your personal life going on at the same time. And you're trying to squeeze in where you can. Oh, you know what, I have time to send this email off from work. And so you kind of want that space at the same time. You kind of want a place where you can focus on some of those things, but at the same time relax. Because, again, I hate being long-winded. I found myself, I work in a pretty fast-paced environment, and it can be stressful. And I really made it a point to try to keep that separate from being a juror and serving as a juror, and not letting those stresses translate into my perceptions of what's going on in court and deliberation. So I think that would really help jurors kind of figure out, you know what, I can separate this if I have a place to do this, and then I can just shut it off, go back into the courtroom with a clear mind.
Ms. Newland, during jury selection, do you think I assume the lawyers did the voir dire questioning of the potential jurors?
Yes.
Questioning of the potential jurors, right?
Yes.
Did you think the lawyers did a good job identifying people who should not serve on the jury, or did they miss some key people?
I think for the most part, they did really do a good job, especially considering the topic is a very sensitive topic when you're dealing with child custody and a modification. There's no doubt there's a lot of feelings there. I thought they did a good job. A couple of times there were questions maybe asked that were, and that was a hard thing for me, as it would be for a lot of you, is setting aside the lawyer brain and just have the juror brain going. It was difficult, but there was some carryover from one to the other, and I think those things could be eliminated. But as far as the questions of the folks, there were a couple that maybe didn't get identified until we were in the jury room talking, and it was like, what are you doing on this jury? You know, in our brains, all of us saying, well, how did you not get excused or whatever? And so maybe questionable there, but it's still, we worked really well together, and ended up having to have one of the jurors excused, which probably should have been done and should have been seen, and it was a fact that she was a medical doctor. And it's just very difficult for doctors to get away, more so than probably a lot of other professions. And she brought that up, but she was very quiet, very timid about it. And once it was done, then it was brought to the judge's attention, and she was excused. We had alternates, so it wasn't an issue there. So I think they could have done a little better, maybe, of fleshing that out.
Let me ask you about this innovation. One of the things that some judges around the country are beginning to do now is require the lawyers to make complete opening statements before the voir dire procedure even begins. So the 50 people, or whoever is brought in the courtroom, the entire venire, sits there, and the lawyers have to make, that's their only opening statement. The lawyers, by the way, who have done this love it, because they think they get a better voir dire by explaining to people what the case is all about. The jurors who are not selected, who have to sit there and listen to it, we've interviewed them, they love it too, because they feel they haven't come to the courthouse and wasted their whole day listening to some lawyer ask her questions about her personal life. So, but they've heard a story, and most of them say, I wish I had been selected for the jury after they hear what the case is really about. And and about the only, and clearly federal judges can do it because a number of the judges around the country are doing it in federal court. I think the state court judges can do it in Texas. It does not require change in anything. The law pretty clearly allows a judge to control the order of proceedings. And so the jurors, we've talked to jurors in trials where that has been done, they have loved it too. So just think about this, judges and lawyers, and you know, what would you have thought about that as an innovation?
Well, I think it would have been great, and particularly, I think it also helps to identify, because when you're sitting there and getting some of these general questions, it's like you sit there and you think, what? And then when you, something that maybe comes out later, that you have a strong feeling against or towards, one way or the other, that might have come out by hearing opening statements, because then you can sort of see how people are reacting to that. And I think it would be a really good thing. And again, if it's not repeated, although it may
Right,
need
would
to
not
be
be
in a,
repeated,
yeah.
it would be a one-time
Yeah,
administration.
I personally think it would be very good both as a lawyer and as having sat on a jury. I think it would help that process for people to understand what it is that the case is about, and then being able to decide, do I already have a predisposed idea about that? Or can I set it aside if I do and really listen and be as objective as I can be?
Gilbert, how about you? What did you think of the jury selection process?
I think ours went really.
I'm sorry if I call you Gilbert, Tim is continuous.
No.
Never.
No, that's fine. That's
Okay.
I'm fine with that. So ours went really smooth. I think both lawyers. I think they asked us good questions. I got asked I think I got asked 3 questions, and after the 3rd question, in my head, I was already like, I got chosen. Because after they asked me what I did for a living, that was the last question, and that was, I want to say it was maybe, I want to say 2.5 hours in, and that was the last question, and I didn't get asked any questions after that, and they were asking questions to everybody else around. And after I told them I was a project manager, and I told them that was pretty much the last question, and they started doing everything else, I pretty much knew I got chosen. So I feel like they asked a lot of questions, the questions they did ask, and the way they introduced the case was, what's the word I'm looking for? I guess the way they introduced the case was good because they were able to pinpoint who was gonna, because of us 14 that they chose, the 12 and then the 2 the 2 alternates, all of us were good picks. I mean, we all sat through really good. We were, I mean, besides the fact that we deliberated for so long because of the fact that we couldn't come to a complete decision. I mean, we pretty much, I mean, they chose a really good, I mean, the questions they asked, I'm trying to think of how to word it. The questions that they asked us, and I just can't word it right. The questions that they asked us just help, like, thin out the crowd, I guess. I mean, like, I can't word it correctly right now.
Okay.
It's just, I'm trying to think of the one question that they asked that, like, I knew half of the people in there were already. Oh, so the case that we were doing was, it was a gentleman got run over by a forklift and he had to have his leg amputated. And so the question they had asked us was, how would you feel, or do you have any, would you be judgmental, or I'm not sure exactly how they worded it, against somebody being on drugs and having their leg amputated, or by somebody somewhere in that nature. And so like half of the people in there were already like, oh, I already find them guilty. Like before they even hear anything, they had already said, I find them guilty. So I already knew those like 8 or 9 people were going to be out. So, I mean, the way they worded it, the way they said it and all that, I mean, they just, our lawyers in there were awesome at the time. So, I mean, I really have no complaints or anything on it.
All right, let me ask you this question. Let's go beyond jury selection. And at the beginning of the case, did the judge give you any instructions on the substance of the case? Did the judge tell you the questions you would be asked? Do you have any warning on that?
She didn't like tell us the exact questions we were going to be asked, but like pretty much like
Summary.
a summary of questions that we would be asked and ins and outs of what we could and couldn't do during that time.
Would you have, one of the things, and we saw the movie, would it have been helpful to you if you had, at the end the judge gives you instructions? I've always wondered why they don't give you instructions at the beginning?
We had full instructions the whole time.
At the beginning?
Yeah. Well,
That was my question.
oh yeah, no, we had instructions. We had instructions.
At the beginning of the case?
Yeah,
About what had to be proved?
yeah. What
Did
happened?
each of you get a copy, a written copy of the instructions? Or is there only one copy sent back?
No, I do not.
You don't remember?
Yeah, I don't remember.
Okay.
Yeah, I'm just getting over a mild concussion, as you can see. so,
Got it.
so.
How about Ms. Bernadina?
Get your card.
Yes. Do you recall any instructions at the start of your case?
I recall instructions regarding how we were to conduct ourselves. I don't recall knowing what the lawyers were going to try to prove. We didn't get that until after. So you're listening
Just-
to all the information and you're not quite sure why they're saying this information. You're not sure. I wasn't sure yet what we were going to be deciding.
One of the things that the judge told you at the beginning is that during the course of the trial, you were not to go on the internet.
Yes.
You're not to do any extracurricular research about the case. Do each of you believe that the people that were on your jury followed that instruction, or do you suspect they didn't? I'm not asking you about what you did. I know you did. I know you followed. I know all four of you followed. But my question, did you ever have we are here a lot, that's a very difficult instruction for people to follow. And actually, if you read the cases on jury trials, that's one of the biggest problems today. Jurors do something they shouldn't be doing, and there's a claim that we need to do the trial again.
Yes.
But do you think the instructions that you got on that were effective in discouraging anyone on your jury from doing that kind of research?
I believe it was effective for me personally. To be honest with you, whenever we were on breaks, I distanced myself from everybody to make sure I was following instruction not to talk to anybody. So I never lingered around, and I made sure, so I can't speak for whether I had a hint that somebody else did or didn't follow it, because I would remove myself.
Where you go for lunch?
I'm just
By yourself?
I'll walk around downtown, just find a different place, so just to kind of get some.
But not with other jurors?
No.
Okay. What was your experience?
I think it's so easy it's so tempting, because who doesn't pick up their phone when they're not doing anything anymore? I think it's very tempting, but I was it was enlightening to see a lot of people actually follow those instructions, because I chatted with pretty much everybody on a daily basis, and I don't think I found one person, but again, it's so easy to be tempted by, you know what, let me just Google this person's name, or if they're a business owner, you kind of want to find out what the reviews are, because I was tempted. I was like, golly, I don't even know this business, but what do other people think about this business? And so it's so accessible and so easy to do, but I didn't hear of any of.
Let me ask you this question. After it was over and you went home, what did you Google about the trial?
Quite honestly, right after the trial, we had the opportunity to speak to the defense attorneys and to the defendants. The plaintiffs didn't stick around, but
They lost?
yes, they did. But it was really, it was a great experience to chat with them, and we kind of, just through conversation, you were able to confirm some of the things that you were starting to lean towards or perceive. But no, I honestly, I didn't really, I think that was enough for me. I didn't really have the temptation to.
Anyone else
to
do
Google
any
that.
research after it was over when it's permissible about the lawyers, the parties, anything like that?
I honestly forgot everybody's name as soon as I left.
Fair enough.
I did on the company that they were suing. I
You
did.
did?
Yeah, I did, and it's because we actually used. I realized that, and I didn't know that we just recently used that company for cement on one of our jobs. We just used them last week, and so I was shocked to find out when I got the invoice that they used them for one of our jobs, like 2 weeks ago. So yeah, So I was looking at the reviews.
Did any of you, in any of your trials, do you think the lawyers repeated themselves too much?
Yes.
The answer is yes.
Yes.
Do you think you could have, the case could have been decided sooner? I mean, in fewer days than it took to try the case?
Yes.
How long was your trial again?
It was 3 days.
3 days.
Yes.
All right, anyone else feel that it just went on too long?
I think the defendants made it very concise. The plaintiffs were a little long with theirs, and it kind of got trying on everybody's patience, quite honestly, in the jury.
So, do you think the lawyers made a difference
Definitely,
in the result?
absolutely.
How about the other three? Do you think they made a difference?
Yes.
Yeah, and I told,
Now, that's a good advertisement for trial lawyers. Listen carefully.
afterwards when we got to speak to the lawyers and everybody, I told the lawyer, I was like, I felt bad because when you were talking to him, you kept telling him, it's just a leg. It's just. You kept saying just. It's just. That was all. You didn't show him no. You didn't show him no emotion. Like you didn't show him anything. You just kept saying just. I go, and I straight up told him to his face. I go, you came off like a butt, but I used the other word. I don't want to say the front of all this. And he goes, no. He goes, thank you for telling me. I go, and so I go, I really didn't have no. I didn't have no emotion. I didn't have anything for y'all when it came to us deliberating over y'all. I straight up didn't. The same way y'all didn't have any emotion for him, I didn't have any emotion for y'all. When it came time to deliberate, I did the same thing you did. It's just a leg. Well, it's just money then. Y'all want to be like that? And the company was right next to him, and he goes, no. He goes, I understand what you're saying. He goes, the way he kept presenting everything and the way he kept presenting it, he goes, I see what you mean. He goes, there was no emotion in it at all. So.
Sparadino, how about you? Do you think the lawyers made a difference in your case?
When you say make a difference, can you clarify if you're asking if I felt that they made an effective case with the way they presented it, or?
Well, let me ask you this. Do you think the best lawyers won?
No.
Actually, the side that won had...
Was aggravating. We had to keep reminding ourselves to keep our emotions out of it because the lawyers were extremely disrespectful. And it was hard.
They were what?
They were extremely disrespectful whenever the defendant's lawyer was speaking every single time. And so it was hard to not notice that and not develop some kind of emotion. And that was one of the main things I do recall in the room. We had to keep telling each other, remember, it doesn't matter if we think he's a jerk. We need to let's keep looking at the questions. And so I will say that was one thing. And we ended up deciding in favor of the plaintiff, but we could not stand that lawyer.
Did you, in your trial, any of your trials, did the judge allow you to submit questions to be asked to the witnesses? Did that happen?
No, that never came up. We never had any additional questions personally.
All right, well, this is interesting because one of the things now, one of the innovations is going on around the country. I think about 50% of the courts in the country now tell the jurors, if you have any questions to be submitted to a witness, you can write them down on a piece of paper. At the end of the witness's testimony, the judge collects the piece of paper and looks at the questions and then either asks the questions herself to the witness or ask the lawyer to ask the questions. The jurors love that, the ability to ask questions. But none of y'all did that.
None of us really had questions. I mean, pretty much all of it was
Did you have,
answered, I guess.
did you have expert witnesses?
Yes.
All the trials had experts. Did the experts make a difference in the result?
Some did, some didn't.
All right. What was it easy to understand what they were saying?
Yes and no.
Why do you say yes and no?
I feel like, I guess some of the terminology they were using and all that, I mean, the doctors were talking to us like we were doctors. Like, they were talking to us like we knew what they were talking about. So, I mean, we really didn't understand what they were saying. Luckily, we had the documentation to look over and all that at the end, and we didn't really, I mean, all of us jurors were like, we really couldn't understand what she was saying. So,
Did you have any trouble at all understanding the written instructions that the judge gave you at the end of the game?
No, they were pretty clear. I mean, they were step by step. Yeah, they were very clear and concise.
Did each person get a copy of those instructions, or did only the foreman get it?
If I recall correctly, it was just one copy.
Would it have been helpful for each of you to have your own copy?
It may have been. I mean, it's not a great expense, I don't think, to make copies
Extra
of it.
copies.
Right, but at the same time, it was, we went through, the foreman read each question multiple times, and she was chosen. She was a school teacher, an elementary school teacher, and we were a pretty immature bunch, so it worked out perfect. No, she read each question several times to make sure everybody understood, and so in the end, it really didn't make a difference.
Did anyone have to send a question out to the judge during deliberations asking about evidence or the instructions of the law or anything like that?
We were real close at one point to getting an interpretation or a definition, but we as a group, we just kind of discussed it and ultimately came up with the correct interpretation of something. But yeah, it was.
Did you find that the judges, were they helpful? Well, you didn't have to ask them
Right.
after deliberation
That's
began
correct.
for any more. Is that true of everyone?
we sent a few questions. I don't remember what the questions were, but they...
Was the judge helpful in answering them?
Oh, yes. We got answers right away.
All right.
I think we sent like 3 or 4, and we got answers right away.
When you got back into the deliberation, how quickly did you take the first vote? I mean, did you begin by taking like a straw vote? Or did you go around the table discussing the evidence before you had any votes? So do you remember that?
On my case, we had like 12 questions to go through because it was 12 different things. So it took us a little while to go through it. But I mean, for the first question, I think we all sat down, and the first like 3 or 4 questions were pretty simple, and we all came to it like within an hour. And we had those first 4 questions. The first question for sure we all had, like as soon as we sat down, we went around the table and all of us knew right away as soon as we sat down. We didn't even need we just went around the table and we all said yes or no. And it was all yes.
All yeses to
Yes,
the first
all
question,
yes. Yep.
which was a liability question.
Yeah.
Okay. And did you award damages in your case?
Yes.
How much damages did you award? Do you remember?
I don't remember the exact dollar amount.
Do you remember how you got there?
We added up everything from damages to like him losing his leg, to cost of living, to pain and suffering to them having to go to therapy to it was just a cost of living stuff. I mean, just random stuff. That's why I was saying it's about 12 questions that we had to go through.
One of the points made in the movie, the video we saw before the panel discussion began, one of the points made is that in life, in classrooms, you typically learn by talking to other students about what you're hearing as you go. Would you have liked the ability to discuss the case among yourself when you were all together in the same room?
Before we deliberated?
Yeah.
No,
Not really.
no. We liked going to lunch, because we would all go to lunch together. We liked going to lunch and just forgetting about the trial and then coming
You
back.
did not spend much time in the jury room? The deliberation room?
Maybe like afterwards while we were waiting to go into the courtroom, but other than that, no. We usually left the courthouse to go eat.
All right. How about the lawyers use, was the acoustics, the visual, how did they show you documents? You remember?
Well, we had there were two different formats. One was an Elmo projector, and the other was on a TV. Would have been nice that it would have been a little bit larger to see. I thought the Elmo was a little bit, I don't know, it's hard, low tech, so to speak. You know, and you'd have to like blow it up and move the sheet around. But I mean, they were both effective methods, but yeah, that's the way they presented everything, the documents.
Anyone had to watch video depositions?
Yes.
Did they last to, were you able to stay awake? Kind of.
Yes.
They tend to be too long, you think?
It threw me off when it was the video and then the I guess the description on the bottom.
The text.
That kind of threw me off because it didn't always line up, and it would throw me off trying to watch the video and watch the text on the bottom. Like I'd rather it just be either or. Like it threw me off way too much. So that's what I think all of us would say that afterwards. It just threw us all off.
Having the text there, well, you know, the point that the lawyers make of
Yeah.
it is that some people learn visually,
Yeah,
some people learn by reading.
yeah,
And, you know, some people learn listening and some by reading. So that gives you both.
yeah.
It's
That's
the
what we were
theory.
all saying.
But you're saying that theory is not in practice, right?
Yeah, all 12 of us were like, man, that just threw us all off. Like it was.
Would you prefer just having the testimony, the people talking with no subtext screening across it? Would you prefer that?
I would have preferred that personally.
Would that happen? You have any thoughts?
Ours didn't have any text, but we knew that the transcript was available afterwards to read it, so it didn't really make an impression on us.
All right, now, I'd like to ask the judges a few questions, if we can.
I thought we were going to get out of here.
No, you're not going to get out of here. So, first place, let me ask Judge Lambert. Federal court, do you allow lawyers to do voir dire?
No,
You do not.
they can suggest questions to me. I ask all the questions.
Why is that, Judge?
Because I think in the state of Texas, y'all can go on forever and voir dire. I'm from D.C. I come down here in the wintertime and try and catch sit feathers voir dire. In D.C., we've never allowed lawyers to ask any questions. In Texas, I follow the same practice. I take suggestions from the lawyers.
Use the mic, Judge.
I take suggestions from the lawyers here, and I usually can get a jury picked in an hour or less. And I think it's the court in Texas that it would be very unusual because you let the lawyers go on forever. We do. We really don't. And I think most of the federal judges here would do it similar to me. I sometimes allow follow-up if I have somebody at the bench and they have some particular thing, then I'll let the lawyers ask follow-up. But
And
across the board, I don't let the lawyers ask.
Suppose I got with, I'm in your court, or get an agreement from opposing counsel, you give us a judge, you can give us each 30 minutes time to conduct voir dire. I can report to you that fortunately, there was a period of time when all federal judges did that. I think now about 50% of federal judges across the country are allowing the
30
lawyers 30 minutes of time. Because what we have learned, see, it goes back in Texas to Joe Jamel and the incredible titans of the plaintiffs' bar that somehow lived on the Gulf Coast. And no, that's true. Texas was the epicenter of trial practice when I became a trial lawyer. And these lawyers would conduct voir dire, and before not a witness had opened their mouth, and the lawyer won the case.
Voir dire.
In voir dire, because it was used to argue cases, and the federal judges got sick of that, and they stopped it completely. And now it's a process generally of bringing the lawyers back in, because I think most lawyers, every lawyer I've seen, want to be able to do voir dire, except the young lawyers who have no training in how to do it. That's a problem we have now. We have a whole generation of lawyers that are litigators and have not been to a lot of trials, and if you feel uncomfortable doing voir dire, then you tell the judge, no, judge, you go ahead and handle it. I'm fine with you handling it, which I understand is done a lot. So, Judge Sakai, you can impose limits, don't you, on voir dire?
Yes, I can.
And so what typically would you give us in your court? How much time?
I pretty much, I will tell you from a year, my senior status over at Bear County, when I first started, there was probably among my peers, the practice custom that voir dire was much more like federal court. Short, put extreme limits, generally time, and when the clock ran, that was it. Over the years, and I believe with the new generation of judges, many are sitting here today, I think there's been a loosening of that, and basically allowing the attorneys to control that. And so my basic instruction to attorney is, I'll cut it off when I think it's too long. And so basically, I try to give as much latitude to the trial lawyers, both to do general and to do individual voir dire. So that after the completion of voir dire, I believe the trial lawyer should have a complete sense of each particular person in that panel. That's my process.
And the state court, Joe, let me go quickly to another topic. The state court judges in Bear County, are you allowing jurors to submit questions to witnesses now? That ain't happening here.
I had it happen in 2 cases where it wasn't, I didn't give an indication that they could, but they came out on breaks with questions. And it kind of was a Pandora's box once that first question got answered, because that particular trial, then a bunch of questions started to come out. And actually, I sought guidance here from Judge Sakai on that issue, because that was a first in kind for me.
I will tell you, basically, on jury note-taking and jury questions, I basically will go to the attorneys and ask for an agreement so that it's on the record, it's outside the presence of the jury. I think as a matter of practice, I have no attorneys that have objected to the jury note-taking. I think that's pretty much standard now in our state court. The jury questions, I'll be honest with you, I've only had one case where the parties agreed. Attorneys, if y'all want to look at this process, y'all are going to have to start being willing to be cutting edge, especially jury questions. Because in that case that I allowed a jury question, it was helpful. It answered questions that I believe the jurors were able to take back. It missed a point that the jurors needed to go back, the attorneys needed to go back to. But I will tell you, when I asked that to the attorneys after both parties rest, and before the closing, I go, can we submit jury questions? And the attorneys have this shocked look at me going, and they just go, and typically the response is, no, we object. And we move on. So I will, as a senior judge there, I'm willing to look at cutting edge practice to help the jurors reach a better verdict, but attorneys, you guys got to get out of your old habits.
Well, Judge, could I respectfully suggest
Yes, you may.
that you see, one of the reasons, what I've learned in doing this is innovations are slow to be adopted, even though they make sense, because of the attitude, well, if the lawyers agree to it, I'll adopt it. The truth of the matter is that lawyers are unevenly matched, as we know. And you have a good lawyer against a not so good lawyer. Y'all have seen that in your cases. It's hard to get the lawyers to agree because one always thinks if it's good for him, it's bad for me. If Sussman agrees, Sussman wants questions, he's got a trick. There's some trick here. If Sussman suggests that we have complete opening statements before voir dire, there's a trick. And if judges continue to require lawyers to agree, nothing will ever change because lawyers aren't going to agree. They are inherently conservative. They do things the way they always did things. They are unwilling to try things. So, I mean, I really think the judges, if we're going to change the way things are done, and maybe change is not so necessary. We have four happy jurors here. But keep in mind, these are very short trials. All the trials you were in were for short trials. Only one lasted more than a week. I think you were there for 3 days or 2 days or some short period of time. Where we get some real unhappy jurors. There's cases that go on for 4 weeks, 3 weeks, 2 weeks even. But we don't have any of them represented. So, I mean, there is, and so some of the things that they're talking about, like allowing the jurors to ask questions, everywhere we've gone where that is allowed, the jurors love it. They love the ability to be able to submit questions. It keeps them engaged. And the lawyers, every time I have a lawyer in a trial on the other side, where questions are asked, the lawyers love it too, because it tells us what we are getting across. One of the reasons we repeat ourselves is that we cannot ask you, how are we doing? Do you understand what I've been saying? Am I making my point? You can't do that. But if we allow you to ask questions, it's pretty obvious where we have fallen short, and repetition is not always necessary to get across our points. So that's another advantage. I mean, I'd say 50% of the judges in this country, state and federal, are now today across the country allowing jurors to ask questions. So, any questions in the audience about, let me ask you, Judge Lambert, how about the idea of opening statements before?
I have not tried it, but I after hearing this discussion today and hearing these jurors today, I certainly think it's worth looking at. And I am amenable to seeing if it would work. In fact, in my next civil trial here, hopefully the lawyers are here today. I agree with you, the lawyers do not have to agree, but I also agree with you that
That's better.
I much prefer it if they agree, because the circuit is not going to reverse me.
But you know, Judge, you can ask them in a way that they are you can say, no, it's a smack, but you could, I really want to do this. I'm sure you would not stand in the way of my doing what I really want to do. Because the Civil Jury Project has told me if I do some of these innovations, they will send researchers to my courtroom after it's over, which we will do. If we know you're going to do some of these things. To ask the jurors right then and there, how do you like it? How did it work? You know, one of the problems we have with jurors, and you're no different than you're great, and thank you so much for coming out today. But the memories of the jurors and what they like and dislike gets very foggy. As one of the jurors here today said, Ms. Fernandina, that when you left the courtroom, you didn't remember anyone's names. It was over for you, okay? So thank you for coming back today and regurgitating of some of your experience, which was largely pleasure. But the point, what we're trying to do is get judges to provide them with a questionnaire, which we'll provide all of you judges, that you can hand the jurors at the beginning of the case and tell them you're going to have an opportunity at the end of the case to complete this questionnaire. You don't have to do it, you can throw it away. You can send it in confidentially to the Civil Jury Project, or you can hand it to my bail. But these are the kind of things we're going to ask you. Yes.
Just briefly, some of our bar may be a little more amenable to having jurors ask questions if they know where you're getting the statistics from. Thank you. Some of our bar may be more amenable to having jurors ask questions if they know where you are getting your statistics that about 50% of judges are allowing this to happen, and whether it opens the door for error. And if so, in how many cases we've seen that.
Okay. I can answer the second question. I've never seen a judge reverse for a question. We read all the cases on jury conduct and so in 5 years. That has never happened to my knowledge. The statistics are not scientific. We get them basically by talking to we have 360 judicial advisors. When we invite them back to these workshops, we ask them these questions, and well over half of the judges from around the country. In Texas, I know the judges in Harris County, for example, just like you, are allowing questions. And there's a rule that says an instruction that you give with a question. Randy Wilson prepared the rule, and I think the Supreme Court has adopted a standard pattern instruction about what you're to tell them. I may not ask all the questions, don't draw any inferences of that. There are things you may ask that you cannot know. And I may not ask questions because I know the lawyers are going to cover it later in the trial. But in every trial I've been in, and so you just need to ask some judges. I know I was in a case with Dix, this is 10 years ago in Dallas, a big case. And we were in state court in Judge Craig Smith's court. And there were good lawyers on both sides. Tom Melsheimer and I represent the plaintiff, Dick Sales, and Dallas represent the defendant. And we got the judge, first I got the lawyers to agree, because that was good lawyers on all sides. I got the lawyers to agree the questions would be fine. We went in the first day, we asked Judge Smith, can the jurors ask questions? He said, no, you don't come in here and tell me how to run my courtroom. It's going to take too much time. It's going to waste everyone's time. They're going to ask stupid questions. The next day we came, so that was it. The next day we came back, and on his own, overnight, Craig then said, I've been thinking, if y'all want to do this, I'm here to be the referee to try the case. If you want to try something and you agree on it, fine. We did it, and both sides loved it, and they have written about it, the use of questions, and Melsheimer and Craig Smith have written an article together, and Dick Sales still says, one of us lost, one of us won that case, but all the lawyers were happy with the result of jurors asking questions. So that's about all I can say. Listen, another question. Yes?
Well, I was just going to say, we had a case in Travis County recently with Judge allowed an actor, each witness, they would do written questions up. And one of the ways to put a governor on it was each question, both sides could object to it. And if either side objected to it, the question didn't go. And there was only one question that didn't go back to the witness. And then the judge would allow the witness to answer, and then they would allow us to do follow-up questioning with the witness as well. And it was extremely helpful.
thank you. There's some evidence of what's going on. So, any other questions? Okay. Thank you very much for coming. Others, thank you for coming to participate. You were great, Julian. Michael, are you going to try to talk to a few of them after this? Yeah, Michael will talk to a couple of them. Because we want to get some short video testimonials. Put you on our website. Thank you very much for coming.
Right. Well, I expect to see a photo of you on a yacht titled USS Priority.